We welcome you to an engaging session that delves into the intricacies of irreversible Hindu adoption and the legal challenges posed by the recently implemented CARA Adoption Regulations of 2022. Esteemed guests and participants, it is an honor to introduce our distinguished speaker, Advocate Anil Malhotra, who will be joining us online for the first segment of our event, Justice to Juvenile. Advocate Anil Malhotra is a luminary in the field of law with an illustrious career spanning over 37 years. His legal acumen covers an extensive range from civil and matrimonial to criminal and overseas litigation. His significant contributions extend to legislative processes, including his involvement in drafting essential acts such as the Punjab Compulsory Registration of Marriages Act 2012 and the Punjab Prevention of Human Smuggling Act 2012. As a fellow of the International Academy of Family Lawyers and the Indian representatives for Reunite Child Abduction Agency UK, he has garnered acclaim for his global expertise. Let us warmly welcome Advocate Anil Malhotra. So can you please give us a minute while we fix some technological issues? So we cannot hear you, we're having some technological issues.
Yes, just give us a 5 minutes. So tell us speaker box loud.
Ya estamos con eso.
Hello? Can you hear me now?
Yes.
Hello?
Yes, yes.
Yes sir, we can hear you.
Can you hear me?
Yes
Can you
sir.
hear me?
Yes sir, we can hear you now.
Okay, fine. Good morning, everybody. Sorry for the glitch. First of all, at the outset, I wish to thank the organizers for organizing such a brilliant and a wonderful session on a very engaging and interesting topic. I was very happy to hear the esteemed views of the Honorable Police Commissioner, who gave a wonderful exposition of child laws extensively. And just by way of coincidence, I wish to applaud the Mumbai police and endorse the views of the police commissioner to say that the Mumbai police is indeed very efficient and very engaging insofar as child rights are concerned. I say so because I was a counsel in a parental child removal matter of a small child from Netherlands. and after the child mother came here to pursue the remedy in a habeas corpus petition, the child, after having been located and the father responding, was temporarily given to the mother. But after she came back from Netherlands, when she again wanted the direct custody of the child vanished and the father took her away. And on the High Court issuing a bailable warrant, the child was recovered within a span of 24 hours in a very efficient, and I wish to applaud the efforts of DCP Zone 9, Mr. Srikant Upadhyay, who personally monitored the operation, and within 24 hours the child was produced in court to enable the High Court to take a decision on an interim arrangement. Now on this note, I come into the topic on which I am to address the esteemed audience today. This is about where are our adoption laws going. From time immemorial, Hindu law conferred a right on parents to give an adoption and parents to take an adoption. As you all know, in our country, our personal law you have a Christian law, you have a Muslim law, you have a Parsi law, and you have a law for Christians. We also have secular laws in some matters, but clearly when it comes to families, we are given a choice of being governed by our personal law, and we can opt for the application of a secular law. Coming straight into adoptions, the Hindu Adoption and Maintenance Act and the Hindu Minority and Guardianship Act are the two principal key legislations in this respect. Under the Hindu Adoption and Maintenance Act 1956, we have a clear, distinct and fine jurisprudence of who can be adopted, who can take an adoption, who can give an adoption, and how can he or she give an or take an adoption. The bottom line is, we prescribe that there shall be a giving and taking of children in adoption. It is normally done by a ceremony called Datta Homan, which simply means that the child is moved from one lap into another lap, and the people who do it fully realize the consequences of what they are doing. If you fulfill all the conditions what Hindu Adoption and Maintenance Act says, thereafter this adoption is considered to be irreversible. Hindu Adoption and Maintenance Act section 16 also says that though it is not required, but if you wish to write a deed of adoption and get it registered, the factum of the adoption having taken place shall not be called into question in any court of law. So this is where we stand insofar as Hindu law of adoption is concerned. Now we move on. India has signed the United Nations Convention on the Rights of the Child in 1992. India is also a signatory to the Convention on Protection of Children and Cooperation and Respect of Inter-Country Adoptions. Now, both these conventions focus on the right of the child, vis-a-vis specifically insofar as adoptions are concerned. The UNCRC is more on right to life, right to nationality, right to be brought up by a family, and a right to have an existence as a person. The United Nations Convention on Protection and Cooperation of Children, Inter-Country Adoptions, is something we signed to become a party to a system of law whereby inter-country adoptions could take place by internationally acceptable standards. Now, at the same time comes another law, the Juvenile Justice, Care and Protection of Children Act 2015. Now, adoptions abroad in our country were in a serious mess, and trafficking of children internationally was a racket. So the Supreme Court, in 3 successive decisions, in Lakshmikant Pandey 1, 2 and 3, in 84, 88 and 89, came out with directions stating that adoption of children has to be streamlined, a system of law has to fall in place, and there has to be a body or an authority to mandatorily control the system of adoptions. So from that perspective came into existence Central Adoption Resource Agency, CARA. Now, CARA was the body which started coordinating inter-country adoptions. Then CARA has now become Central Adoption Resource Authority and has become a statutory authority. Why and how? After India signed the Adoption Convention 1993, India was required to create an agency, an authority, which would coordinate with authorities, central authorities of other countries, signatories to the convention, and where children could be brought from one country to the other through a system of law and permitting children to be adopted from one country and or the other. Now, when we signed the convention, we had to therefore amend the Juvenile Justice, Care and Protection of Children Act. It was an Act of 86, then it became an Act of 2012, and now it is an Act of 2015. So all the principles in the Adoption Convention, in the UNCRC, have now been incorporated in the JJ Act 2015. So to give teeth to any international convention, we have to per se absorb them in our domestic law, and that is how they get teeth of enforcement. Now, to start with, JJ Act 2015 was meant only for orphan, abandoned and surrendered children. And the focus, motive and primary purpose was that children who do not have parents will be monitored by CARA and sent abroad by a regulated mechanism whereby they were not trafficked, sold or misused. That came the primary laudable purpose of the JJ Act and CARA. Now, when CARA came into existence and when the JJ Act was amended, the conflicts started coming. To start with, Section 56 of the JJ Act 2015 said that adoption shall be resorted to by ensuring the rights of family for the orphan, abandoned and surrendered children. As per the provisions of this Act, meaning JJ Act, the rules made hereunder and the adoption regulations framed by the authority. Adoption to 56.2. Adoption of a child from a relative by another relative, irrespective of the religion, can be made as per the provisions of this Act and the adoption regulations framed by the authority. I'm going to pause here. Now, we must not keep away from our minds that adoptions by, for and of Hindus was strictly governed by the provisions of HAMA, Hindu Adoption and Maintenance Act. Then came the judgment authored by Justice Gogoi in Shabnam Hashmi's case. Now in Shabnam Hashmi's case, Justice Gogoi says that adoption of children under the JJ Act is a secular law. Hindus, Muslims, Christians, anybody can avail it. But it is an option. You can adopt under the JJ Act as Hindus, but you have your sacrosanct right to adoption as Hindus under the HAMA. So it is in this context, Section 56.3, which is a standalone jurisprudence, says nothing in this Act shall apply to adoption of children made under the provisions of HAMA. Now, Section 56.3, having said so, has a conflict with 56.4, where it is said that all inter-country adoptions shall be done as the provisions of this Act and the adoption regulations framed by the authority. So this creates a dilemma for some, that on the one hand you are saying that adoption of children made under HAMA is standalone, but at the same time in 56.4 you are saying that all inter-country adoptions shall be as per the provisions of this Act. Now, when you do adoptions under the provisions of the JJ Act, you have to follow the procedure in the adoption regulations. Now, the adoption regulations have been undergoing changes very fast. 12, 15, now 22. And the regulations, in my view, are corrupting, overdoing and overtaking what the Act says. So, where does the conflict come? The conflict comes when the adoption is an inter-country adoption. Now, any inter-country adoption, whether of a Hindu child or of a child of any religion, by the process of JJ Act, let us deal with that first, is governed by a procedure. Means, if you want to adopt a child from India, you will apply to the adoption agency or the concerned authority in your country where you live abroad. Your request will be assessed, sent to CARA in India by the authority of that country. You will be registered under this list in CARA in India. You will be matched. A child will be put to you. You may see the child, and then you enter into a process of evaluation. Ultimately, the process having taken place, you are supposed to go back to a court and get an adoption order. Now, CARA, first of all, has in the adoption, has by an amendment of the Act itself, demolished the word court and has brought it down to a magistrate, which means an executive magistrate can now issue an adoption order. This is one serious conflict which has crept in. The reason which CARA says judicial courts take a lot of time, so therefore executive magistrates are faster to deal with. Now, whether an executive magistrate has the judicial eye, the discretion, the knowledge of law and the best interest of the child is a question which remains to be tested. So initially, this procedure of CARA was meant only for orphan, abandoned and surrendered children who, after having undergone this process, were issued a no objection certificate by CARA, and then that NOC would help the adoptive parent who had adopted under the JJ Act to go to the embassy or the High Commission of the country where the child is to migrate to obtain an immigration document to leave the country. Ordinarily, the passport officer would also give a passport to the adoptive child on the basis of a birth certificate, on the basis of an adoption deed or an adoption order, and the child would leave. Now came the conflict by two judgments of one Punjab and Haryana High Court, in which I was an amicus, Jasmine Kaur, and one RK, authored by the Delhi High Court. Now, in these two cases, both the courts in different cases said that any adoption taking place under HAMA does not have to undergo the procedure of processing for orphan, abandoned and surrendered children, because Hindu adoptions are standout, and therefore the adoption regulations procedure will not apply. So what does CARA do? CARA amends the adoption regulations and brings in within the fold of the procedure of CARA Hindu adoptions also. So this means that Hindu adoptions, which are irreversible under the Hindu Adoption and Maintenance Act, have to now undergo the scanner and screen of adoptions prescribed under the JJ Act. The conflict is that once a child is taken in adoption by a Hindu parent adopting a Hindu child, let us say of a relative, and he obtains, let us say, a court order and a registered adoption deed, a birth certificate, and an Aadhaar card, does he have to submit to the entire drill verification process and clearances process of CARA and go to NOC and go to CARA and take an NOC? Looking at the laws straight, the statutes, in my view, no. Once 56(3) says, nothing in this act shall apply to adoption of children made under HAMA. So, the adoption regulations, by bringing in the adoptions made under HAMA within the fold of the JJ Act, have watered down the act. For those who are practicing law, the question is, can regulations do down an act? Can regulations infringe a statutory right given under another enactment? Answer is no. I give you a live matter. I was recently a counsel for a gentleman living in the US who, with his wife, adopted his uncle's grandson, underwent the procedure of religious procedure, watered it down to a written adoption deed, obtained a certificate from the district magistrate under the regulations, obtained a birth certificate, obtained an Aadhaar card. But when he went to the passport officer for a passport, the passport officer says, I am not giving you a passport till you get a NOC from CARA. Now, just to fill you in, under the Passports Act 1981, a passport can be declined on 13 grounds to a person. There are judgments to the effect that say that except for these 13 grounds, the passport cannot be declined to any person. So the passport officer turns around and says, I've got a passport manual, and in that passport manual are some regulations, non-statutory, which prescribe that even an adoption of inter-country adoption of under the HAMA, I need an NOC from CARA. So the man is refused a passport, saying go and get a NOC from CARA. When he goes to CARA, CARA says no, we have amended these regulations. Now you have to follow our procedure. So following the procedure meant for orphan abandoned children, the man has to go back and stand in the queue in the US, join in the queue, wait for his turn, then he has to be matched with a child, then he will come to India, and then they will give him a child. So the question in law is, what does he do with that child which he has adopted of his uncle? Should he return the child? No. Why? Because the adoption under HAMA is irreversible. He does not need a certificate from CARA. So I challenged the vires of the adoption regulations 2022, and I challenged the constitutional validity of the adoption manual imbibed by the passport officer, and said these are unconstitutional. How can you invalidate a personal law by regulations made under another law which is only applicable to orphan abandoned children? On the one hand, India is advocating rights of the child under the UNCRC. India is identifying rights of children under various other conventions which the police commissioner talked about. And on the other hand, you are taking away what a law has done. So are Hindu adoptions to be sacrificed at the altar of a secular law? Is the controversy. The Supreme Court of India is looking at, in a PIL under section 32, everything in a larger holistic purpose. Now, as far as my case was concerned, the gentleman who adopted the child had 2 daughters. He was living in the village with 1 daughter. His wife went back to the US with the other daughter, and the family was split for 2 years. Now this is happening in every state in the country, because CARA is sitting over every Hindu adoption and questioning every Hindu adoption and telling people, you go to the embassies and ask for clarifications. I and my client went to the US embassy and said, we would like to know, what do you need to give us a visa for the child to leave the country? They said, if your adoption is valid under Indian law and you have been living with the child in India for 2 years, we have no problem. We will give you the marriage visa. Now, what I wish to stress is that the bureaucratic red tape, which the police commissioner also talked about, of CARA saying we have to follow the adoption convention, only then we can look at it. Now, when you look at the adoption convention, In the Adoption Convention itself, Article 23 of the Adoption Convention says that if there is an adoption certified by the authority of the state of the adoption having been made in accordance with the convention, it shall be recognized by the operation of law in other contracting states. Then Article 37 says, if in relation to a state with regard to adoption, it has two or more systems of law in operation to different categories of persons, any reference to the law of that state shall be construed as referring to the legal system specified by the law of that state. So in simple words, the convention, realizing that in a country there can be two systems of law in operation, it says both will be recognized. Now in my view, all CARA has to do is to issue what they have started calling letter of acceptance, conformity certificate, or simply endorsement of the adoption, and which will enable the parent to go to the embassy and the passport officer to do both, asking the adoptive parents to start all over again, to follow the procedure from the start meant for often abandoned and threatened children, I think is a usurpation of power by CARA, which mandatorily is in conflict not only with the rights of parents but with the rights of the child also. Now, what is the zest, zeal and overdrive of CARA? I don't know. In my view, CARA, being a statutory authority, should be headed by a person of judicial training. Ideally speaking, not a sitting judge, but a retired judge, a chief justice, or a Supreme Court judge should be heading CARA, because bureaucratic red tape is in the administrative hands, is not giving CARA a good color. So in the absence of anybody, an official of the Ministry of Women and Child Development becomes the CEO of CARA. And in the bargain and in the process, the entire purpose of creating CARA is lost. Was CARA meant to facilitate adoptions, inter-country adoptions particularly, or to the contrary, is CARA meant to frustrate Hindu adoptions? Is the moot question. Sitting in the north in Chandigarh, I can run to Supreme Court, I can run to CARA. What about somebody sitting in the remote end of the country in Kerala, Maharashtra, Assam, West Bengal, or Mumbai too? How many people specialize in this area of law to understand the nitty-gritties of what is going on? So what happens? You fall prey of agents, you fall in the hands of agencies who go on your behalf to Delhi, and parents from foreign jurisdictions keep waiting for years together. I'm telling you, it's 5 years. It is devastating on the child. It is very cruel to the family who are split. So this chaos, which I managed to highlight in the petition I raised, has motivated me to speak on this platform so that you gather awareness. As a young audience, as students, lawyers, you must generate a thought process against this. There are such good enlightened people like the police commissioner who just spoke. People like him should be heading commissions for protection of child rights. Now that is another very important wing of the system which we have created. There is a Commission for Protection of Child Rights Act 2005. People do not even know about it. Under that act, every state is empowered and mandated to create a Commission for Protection of Child Rights. I was a court counsel for the Commission in a matter after there was a serious abuse again in which I was a court appointed counsel to look into child rights abuse. That these commissions came about in the state of Punjab and Chandigarh. Now this commission is actually meant to be a watchdog on child rights and issues of child abuse, molestation, sexual offences. The commission has a right to stand up and take the issue up with the government, and if the commission is not satisfied, the commission can file a petition to the High Court straight. So this conundrum is making Hindu parents suffer and sit silently waiting for something to happen. Now look at the passport officer. He says, I am a man who has to follow a system. My manual says, I am not bothered about what the JJ Act says or what does Hindu law state. And he says, if you have a problem, go and talk to the ministry in Delhi. So does a parent of Indian origins living abroad but temporarily in India keep going from passport office to CARA or go to agents? And how many years does he waste? And what is the biggest damage? Rights of the child. The child doesn't know who is his mother. The child doesn't know who is his father. And the man and the woman who have adopted a child, let us say, is an uncle's grandson or a granddaughter. Now, can he go back to his uncle and say, oh, I'm so sorry, the system doesn't allow it. Can you please take the child back? Or can I go to CARA and say, oh, so sorry, I didn't follow your procedure. Can you please exchange the child? Give me some other child. What are we doing? Under the guise of grabbing power, is CARA destroying Hama? Is CARA destroying the ethos of Hindu adoptions? We are a by-majority, a society comprising of Hindus with many other communities and minorities. When we have built a system within our personal law to protect the rights of children, do we need CARA to come into our home and tell us what to do? Where is CARA in our home? CARA is the mother and the father giving, CARA is the mother and father taking. What CARA does to orphan, abandoned and surrendered children is not required in Hindu adoption. Why? Because the parents who are giving and the parents who are taking are CARA. They are looking into everything. And a Hindu adoption is validated by virtue of certain conditions laid down in Hama. In respect of age, in respect of acceptance, in respect of giving. And it was made so simple that you do not even have to write a deed. You just झोली में से लिया और झोली में डाल दिया. Where is CARA in all this? Why must CARA say जी नहीं पहले हमारी झोली में डालो फिर हम किसी की झोली में डालेंगे? That's wrong. The ethos of Hindu adoptions, I say it with emphasis, is being destroyed under this secular law by watering down the regulations and, if I may say so, CARA usurping powers. As a lawyer, I have no qualms in making a statement because I have said it in a petition. And I am not bound by a code of conduct of an officer. If the police commissioner can speak so freely, I think I am as a lawyer enlightened and emboldened to say that this is something you must raise your voice about. Because people who are concerned with this problem have no clue about it absolutely. And unfortunately and sadly, judges, judicial officers, at the grassroots level also have no clue. They are also clueless because CARA or the authorities who manage the JJ Act have removed the word court out of the adoption jurisprudence. But can you change the definition of the word court in HAMA, in HMGA, in the Guardian and Wards Act? Can you? No. So by bringing in the high horse of CARA and CARA's drive to speed adoptions, by changing the word from court to magistrate, has it done any good? Now, a district magistrate issues a license, a permit, a particular document to authorize, non-authorize something. The executive magistrate probably does not even have to apply in mind, because all he has to see is on the file noting if everything has been done and the permit license quota is issued. So, is the approval of an adoption involving human lives, which is to be satisfactorily achieved, which has to achieve certain mandatory conditions, to be screened normally by a judicial judge, can you equate a child to a child's approval of adoption to a license, quota or a permit? Is a child a commodity? Should a certificate of an executive authority be replaced by the judicial eye of a judgment of a judicial court? No. Any order under the Guardian and Wards Act, any procedure under the Family Courts Act. Now, under the Family Courts Act, explanation to Section 7 says all these matters will be governed by the Family Courts Act. Adoption is one. And who is to do it? The family court. Can the executive magistrate become the family court by virtue of a play of words in the JJ Act? No. So, by changing the word from magistrate to magistrate from court, deours what the other provision of law says, is murdering the laws and subjecting Hindu adoptions to a process of checks and balances meant for orphan and abandoned children has created a very peculiar situation. CARA has to appreciate that the exercise they do, very well justified, very important and very necessary for orphan and abandoned children, cannot be applied to Hindu children given and taken in adoption under HAMA. So, this is the long and short of what I have to say in the time allotted to me. And having crystallized and having pinpointed the issue in my plain words, without reading judgments or without reading statutes, I now pass on the floor to you to ask me questions, doubts, views, opinions, or any suggestions you may have, so that I can use them in the next case. Floor is all yours. Do we have a mic in rotation?
So we are just going to rotate a mic around. Give us 2 minutes. And if anybody who has any questions, please keep them ready. We'll be be asking you.
Good afternoon, sir. I hope you can hear me. Yeah. This is Advocate Shahin Shinde from Pune. I am a practicing lawyer in Family Court Pune and also mediator in Pune Family Court. My basic question is when we say that adoption is irretrievable, I mean it is not reversed, but we have seen practically that when children are adopted, and sometimes they behave in a very different manner, although they are brought up in the family in a stretch for many years. But जैसे कुछ चीज़ें होती हैं जो दिखाई देती है उनमें कि they are not matching to the family और upbringing कितना भी अच्छा करने का कोशिश की जाए, but then some habits are there which bother the parents, adoptive parents. So in that case, I feel कि ऐसा कुछ होना चाहिए wherein some counseling centers specially made for adopted children, so that they can be उनके साथ बात की जाए, उनके साथ काउंसलिंग की जाए, and some medical support can be given if some things are seen like this. I don't know whether medically this is approved or not, because I spoke with few people. They say few people said कि no. जैसे हम लोग बोलते हैं कि कुछ चीज़ें खून में होती है, कुछ DNA में होती है. So whether it is medically supported, I am not aware of that. But then few habits we tend to see in children, adopted children, which do not match with the family. In that case, we need some kind of counseling done to both to parents as well as the child, so that their family life becomes more with the harmony. They can stay within in a harmony. That is what is my question. Whether this kind of platform is required or not, what you feel about it?
I perfectly agree with you that this is a very crucial and a very critical thing. I share with you my experience. I do a lot of queries, expert reports and opinions for children who have been taken abroad in adoption, or children who are victims of problems faced abroad and are sought to be taken in care or made wards of the court and then sought to be sent to India to be adopted by their grandparents or relatives, or children who have been taken in adoption from India and have been found to have been sexually abused abroad or molested or being in conflict. There are also cases of children being sent in adoption to India when children have problems abroad and the adoption is sought to be cancelled. Now let me tell you very honestly, there is no bar that you cannot do it. I think if you take a petition to a family court or a petition to the guardian judge under the Guardian and Wards Act, where there is no family court, you can raise the question of the cancellation of adoption in the same way that you would raise a question regarding, let us say, guardianship or custody. But then the question is, who is empowered, who is the authority empowered to nullify, cancel or invalidate this so-called irreversible adoption? The answer is very simple, a family court. The matter has to go through a judicial lens. It has to go through the hands of a family court judge who with his experience, who with his maturity, who with his judicial wisdom can assess that this is a wrong adoption. It should be reversed and it can be cancelled. Now, it was made to look irreversible for the simple reason that people would not misuse it. And people would adopt fully well realizing that this is an irreversible adoption. But if there is an exception to the rule, there is no handicap. It is just that you have to think out of the box. You have to make a petition in such a way whereby bringing cogent evidence, relevant material, which will be tested and checked by a judicial court, that is the family court or a guardian judge, you can say this adoption needs to be reversed. So this is not something which is not impossible. I give you an example. I dealt with a matter abroad where a North Indian gentleman had married a white lady. Now the white lady was a drug addict and she was a prostitute. He fathered 3 children with her, and they were unfortunate observant to all what was going on in the family home. Now the local authority came to know about it in England and they took the children away and placed them in foster care. Then the husband's sister in North India wanted to adopt and she adopted. She brought them to India in a North Indian town. She was very happy with the children initially. But then the lady realized that out of the 3 children, the 2 boys were eyeing her daughters because they were brought up in a different atmosphere. So we got the adoption cancelled, we got the guardianship and adoption cancelled, and the children went back. There have been cases originating from states in the south whereby children sent to England on adoption have been abused by adoptive fathers. Adoptions were reversed and children were sent back. You cannot make a child suffer a process just because it is a so-called irreversible process. No, the rights of the child are sacrosanct. The definition of best interest and welfare of the child under the Juvenile Justice Act, you see any law, best interest and welfare of the child is sacrosanct, it overrules everything. So please don't have a concept that it is irreversible. Nothing is irreversible in law, provided you have the evidence and cogent material to reverse it. Next question, please.
Yes,
Go in the
sir.
back. Yeah. So,
Sir, myself Dr. Sheila Shivani and I am academician. And sir, my question is relating to Hindu Adoption Act. When the adoption deed is made by adopted parents, at the time of registering adoption deed, child's original birth certificate is submitted by the natural parents. But after adoption, the adopted parents don't want to disclose this fact to the child. Then my question is that can we change the birth certificate of a child after adoption? And what is the procedure for that?
see, law officially allows you to get a fresh birth certificate with the name of the adoptive parents. Law also allows you to get an Aadhaar card in the name of the adoptive parents. Law also allows you to get a passport with the name of the adoptive parents. So law facilitates the stepping in of the adoptive parents and removing the name of the natural parents, biological parents, from record. There is no bar, it is done officially. As long as you have the requisite paperwork to show that you are the adoptive parents, nobody objects. And you can get fresh certificates and the names are deleted from record. No problem. Next question, please.
Due to time constraints, we'll be only having one question now. So that will be the last question.
Okay, my name is Advocate Ankush Pal. I practice in the Family Court of Mumbai. My question to you, sir, is how does one delay deal with the process of delay that is there in the adoption? You know, what are the remedies available to the child being adopted and to the parents who are adopting this child, because there is a considerable delay in the process. So is there any remedy? Is there something that can be done?
See, are you talking of adoption of an orphan, abandoned, surrendered child under the JJ Act?
My question is regarding both the processes. Wherever
See,
there is a delay.
just a moment. First of all, let us deal with Hama. In Hama, all you need to do is give the child, take the child, do a ceremony, write a deed if you want to be very careful, and that's it. And then go to the passport officer and say, please give me a new passport, get everything. The problems come when you have to take the child abroad. Because the embassy of the country will not give you a visa till you go to CARA and get a clearance that the adoption is in accordance with conformity with Indian law. So you go to CARA, push it. If CARA delays the process, file a writ petition in the High Court, say they are delaying the process. Unfortunately, we have come to a system that unless we use the stick, administrative authorities do not listen. So the better the stick, the harder you use the stick, more often you use the stick. You're a lawyer, you understand what I mean. See, it is so sad that there are now agencies and other people facilitating the process of adoption in CARA. You know what I mean. You can fall into wrong hands, but I would suggest you should not fall into wrong hands. File a petition. I went to the High Court. Now I told my client, I said, listen, we have to challenge the wiries, otherwise we'll keep prostrating. And they will keep delaying. Even after challenging the wiries, it wasn't easy. We were told, oh, you should visit CARA, we did it. Oh, you should do this, we did it. So ultimately, we found a narrow passage and we went through it, we did whatever they wanted. It took almost 4 months, but then we got away. But there are people doing inter-country adoptions sitting, waiting for 4, 5 years. And that is just because people don't know that you can go to the High Court and say, CARA is a statutory authority. It is amenable to the jurisdiction of the court, being authority under Article 12. Issue a writ. See, sadly, filing a writ petition is becoming a panacea for all ills in our country. Because of bureaucratic delays, because of procedural delays, and because some things are falling into place in a system that unless and until you facilitate the process, I'm using mild words, nothing happens. So, you are a young lawyer. I always tell people, jump on the table of the court and argue with vehemence. So, being a lawyer, explore out of the box. Think differently. We are coming to a stage in time where we need family law practitioners exclusively. If you are a family court lawyer, you should not do any other work. In Bombay, you have this scope. In 90% states, this is not the situation. Maybe Bombay, Delhi, Chennai, Bangalore, Kolkata. In the north, there are either no family courts or one judge is doing 5 jurisdictions. A family court. Somebody has a question? Yeah.
So my name is Advocate Anjali Singh. I also practice in family court background. Now, as we spoke about, CARA's inspiration was to prevent offshore trafficking, inter-country trafficking. As we spoke about it, that even if the children get adopted, there is a probability of them entering into trafficking. Even if it goes through CARA, even if it goes through HAMA, there is a probability of the same offshore trafficking happening. So I wanted to know the provisions in CARA, or what is the mechanism that is implemented to ensure that that is not happening, or any case that you have that could help me understand it, is what I want to know.
See, when you do an inter-country adoption through CARA, the central authorities on both sides have to exchange reports on the welfare of the child. Now, the country in which you put in your application will have an agency which officially for that government processes the adoption. That agency will be requested by CARA to send reports back to CARA in India saying all is well. And abroad, they take these issues very seriously. If they find something is wrong, they just pick up the child, and they just hand over the child to an agency, and off it goes. And many a times they go in an overdrive, because if there is an Indian ethos, there is an Indian family, let us say, they may discipline the child, they may scold the child, they may even slap the child. They may make the child sleep with them, because that is Indian ethos. Now, for a foreigner to understand why is the child not sleeping in a separate room and why is the child sleeping in the bed is a big problem. Mrs. Chatterjee, Mrs. Banerjee, I mean, you see so many cases. But then is the question of abuse, very serious. And the moment any agency abroad finds the child is under abuse, the child is gone. I told you I have dealt with cases where children from some states have been abused by adoptive fathers. Once the agency notices it, they get a special guardianship order from the country, giving the child in adoption back to somebody in India, and goes back the child. So there is an inbuilt system in CARA, in the adoption regulations, which is good to that extent. It is meant for often abandoned and stranded children. But as far as the children adopted within the family are concerned, there are uncles, aunts, nephews, relatives, and our CARA works within the families only. We don't need a CARA. There is an inbuilt CARA in our families. Next question.
Sir, due to time constraints, we cannot address all queries. Please communicate them to us. We will send them across to us, sir. We are very sorry.
Okay, wonderful. So it was very nice engaging with you. And you can take my email ID and we can reconvene a session on this, because this is an area where intellectual property is scarce. And I have plenty of it, so we can balance the commodity and distribute the aftermath once again. Thank you very much.
Thank you, sir.
Thank you for your motivational remarks and the insights and experience you shared with us, sir. We're inspired and encouraged to advance the cause of justice by your fervor. We will now